I am joined by two of my very good friends, Eric Rubenstein and Ronald Chapman II. We just got done doing a live, well, of course, live uh, panel discussion at 9:45 this morning on the False Claims Act, fraud, waste, and abuse from a law enforcement, a litigation, and regulatory compliance perspective. So what I thought I'd do is connect with Ron and Eric and basically go through a little bit of what we talked about during our session, some of the reactions that we got, and we'll just kind of play it by ear and see how it goes. This is not going to be a full Compliance Guy episode. This will probably be about a 20-30 minute conversation once Eric learns how to use his phone like a grown-up. So with that said, guys, welcome to the podcast. Thanks so much for being in the session that we did this morning. We had a packed room. We were actually, Ron and I walked in and we were like, whoa, this thing is huge. They put us into a massive ballroom and every seat was taken. Plus, I think you said we had 300 people or so, 200, 300 people streaming?
Yeah, there was about 300, I think, very actively participating on the webinar, which was great.
Good deal. So our panel conversation was focusing on, as I said, again, fraud, waste, and abuse. We got an opportunity to really talk about the False Claims Act and to explore sort of what's going on. And I think one of the really neat things, Ron, that you brought up first thing this morning was the conversation about that even though the False Claims Act is a knowledge-based act, people don't act knowingly without acting with intent. Can you talk a little bit about that and explain that for our listeners?
Yeah. This is just a strange idea. I think the way that I started talking about it this morning is discussing the fact that the efforts of the Department of Justice and the federal government in general have been to try to water down the intent components so that we're getting some feedback there. Huh?
Of course, it's Eric Rubenstein.
It's not me. It's not me. I promise it's not me.
Let's see.
It might be me.
All right.
Phones might be a little too close together.
And if you'll speak directly into the mic, so we'll have your volume.
Yeah. So the issue is the federal government has engaged in a concerted effort to try to water down the intent component for both liability under the False Claims Act and the healthcare fraud statutes, so that the decision as to whether or not a case should be prosecuted criminally or civilly often rests with the individual prosecutor or who's willing to take it, or, as Eric pointed out, the resources available within that office. Right now, as it stands, the nuanced difference between the two different definitions, what constitutes healthcare fraud and what constitutes a false claims violation, isn't really clearly known even to the federal judges and certainly not to the juries. And so it's very possible that somebody who just committed a False Claims Act violation can be guilty of healthcare fraud if they don't put on the right defenses or make the right statutory arguments, or don't have a federal judge on their case with the type of backbone that's required to kick a healthcare fraud case out when it doesn't meet the intent component, which is a very difficult thing to find.
Yeah. And it's such, look, it was a fascinating discussion that we had this morning. But I think one of the other things that I really started, that I got an opportunity to listen to, Eric, as you were going through at the very end, we were talking about criminal versus civil versus administrative. And you gave a great breakdown between what happens when you, as a law enforcement professional, believe that you have a potential criminal matter. It gets declined. You go back to the civil. Again, for whatever reason, they decline it, and then it turns into a potential CMPL. Can you walk the listeners through that process as an investigator or a law enforcement professional as to what all that entails?
Yeah, it's an important distinction, because from an investigative perspective, let me just grab this here. From an investigative perspective, an agent, when they get a case, isn't making a determination, oh, this is criminal, this is civil, this is administrative. that kind of comes about while you're working on the case. And if you're a shrewd investigator, you try to identify that earlier than later. And you go to your assistant U.S. attorney and you say to your criminal lawyer, you say, hey, this is a great case, but it's a better case civilly than criminally. Now, that only comes from years of experience, right? Like, I had a mentor who really taught me the ropes of how to be a good investigator, and that was part of that mentoring and that training process. So a little bit of it is intuitive. Hey, this doesn't really smell right. It doesn't pass the stink test, but does it pass the criminal stink test? Is it worth going through all those machinations for something, or is it better handled as a civil case? You're really getting that, the lawyers love to say that mens rea, that requisite knowledge that someone needs. Or is this something that's better treated as an administrative or a civil case? It doesn't mean that your investigation is going to be any different, right? The investigation is the investigation and the facts are the facts, but it certainly is going to help you with understanding who your audience is, because that's an important piece of the puzzle. A criminal audience is very different than a civil audience, and trying to get a criminal prosecutor to agree that there is something there when there isn't, it's a lot more effort you have to put in versus a civil case where you can kind of collectively say, hey, there is a problem, let's see what this issue is. And I think, when you read a lot of the press releases out there, you see all these cases where when you're reading the press release, at least in my mind, I read these press releases and I go, man, why was this handled as a False Claims Act case, not a criminal case? Now, we're looking at this from the outside in. We don't know what the facts are. We don't know what the story is. But you look at some of these and you say, hey, there's got to be some factor that says this did not give someone the rise to think it was a good criminal case. And I'd like to think, having worked now with a lot of criminal defense lawyers, that a good criminal defense lawyer got in early and often and got someone to realize this is a problem, but it's not a problem that requires handcuffs.
So you brought up a really interesting point about, and I wish you would have brought that up during the panel discussion today about mens rea, right? Because we're talking about the knowledge standard. Ron, with the scienter or scienter, I'm from South Georgia, so I kind of make up words as I go along. Can you talk a little bit about what's been going on with that standard and why there's been so many questions around that and how it ties to the knowledge base of the mens rea?
Well, yeah, I think the biggest development to talk about is the idea that somebody can be willfully blind in a healthcare fraud case. There's a Supreme Court case that came out a while ago. It was actually a patent case, but it's Global Tech, which anybody in the legal field dealing with deliberate ignorance should really understand. And that case discusses where affirmative duties come into play when somebody can be willfully blind. But let me just break it down very simply for everybody. Healthcare entities have an affirmative duty to look at their compliance programs, to have a compliance program, to try to maintain compliance, and to try to understand Medicare rules and regulations. That affirmative duty comes into play when you sign that 855 or other form. You have created an affirmative duty for yourself. If you're not doing the work after creating that duty, the government will consider you to be willfully blind. I disagree with that notion, but that's the state of the law right now. If you don't have that compliance program set up and your entity is engaging in conduct that could have been discovered through the use of a compliance program, an internal auditing and monitoring, or a complaint program, the government is likely to consider you to meet that mens rea requirement because you have remained willfully blind to your obligations. The legal problem with this gets kind of weighty. One of the issues is you can't, unless there's a strict liability statute, you can't create an affirmative duty and hold somebody to it when it is a specific intent offense. You can't say you are guilty of a crime because you did not do X, Y, and Z. That was an affirmative duty to you. That's a fight for the courts later on, but for all of those people practically listening out there, the thing to know is that the best way to defeat the intent component, and we described this during the talk, is to have that compliance program, auditing and monitoring, experts looking into stuff, and trying to make it better. You slide that across the table to a healthcare fraud prosecutor or somebody handling an FCA case, and nine times out of 10, you may open up your pocketbook, but you're not going to get thrown in a cage.
And that's critical. Go ahead, Eric.
So I was going to say that the thing that becomes an interesting piece of the puzzle is when you throw in things like TPE, right? Like you've gone through, so for those that don't know what TPE, which is a target provider education, it's typically 3 rounds of education. And if you fail 3 rounds, meaning if you haven't fixed your problem after 3 rounds, you get referred to the UPIC, and the UPIC will then put you on a prepay. And what I would always say is TPE is the criminal investigator's gift.
That's right.
Because if you've gone through TPE and you have failed TPE 3 times, you clearly have been educated, you've been trained, you've been given all the requisite things. And I know when I do it with some of our provider clients, when we talk about education and training, we'll get a provider client who says, we want you to do an audit to see where we are. I'm like, okay, but what do you plan on doing with the audit once it's done? What do you want to do? Well, we just want that as a benchmark. Well, for what? If you're not going to do education and you're not going to train your staff after the fact, what's the point that you're getting to? But I say to them, always keep in mind that it's a double-edged sword. If we provide this training and education to you, and you still have a problem, later on that could come back to bite you. So by the way, do you have a law firm that you work with? And is that law firm that you work with helping you come up with a compliance program so that we can work with that law firm to create that compliance program and do an audit and training and education in support of the law firm putting together a compliance program? So we're doing it under privilege, which can kind of help to stave that off. But the TPE program is the greatest gift. When we would see referrals, and I was an OIG agent, we would see referrals where the provider had been previously educated and had an overpayment, and they're now back for the same thing. So that, how do you get around that intent piece, right?
Yeah, well, and here's what the government does, and this is what they did in the Bothra case that Sean was involved in. We hit them on the head during Sean's expert testimony that they did not go through the TPE process. And the government's response to the jury was so enlightening. And some may accuse me of being slightly shaded to the defense side, but it was very enlightening. They said, well, of course we didn't go through TPE. This is a fraud case. And we don't want to highlight the fact that we're investigating the doctor by suggesting education. Here's the problem with that sentence. In like a legitimate Bernie Madoff type scheme, I get that, right? But when your allegation is violation of an LCD, an intricate component of Medicare, not even rules or regulations, but sub-regulatory guidance, you can't just say from the outset, this is a fraud case, because you're assuming the outcome of the investigation before you even engage in it, which is the fundamental process that a lot of these people do.
But doesn't that also presume that the person that's the target of the investigation understands what the LCD says and is taking some affirmative steps to circumvent it? Like if you have an LCD that's confusing, how do you show that the person is intending to do something before you've done the work to show that it was just the confusion?
Exactly. Yeah. Go ahead.
So a couple of really interesting points that you guys have been making, and I'm intently listening to it because I want to kind of unpack some of that, right? So, Ron, you started talking about strict liability, and we got into this conversation in the panel discussion where you specifically gave an example about, if you're speeding down the highway and you get pulled over by a police officer, you can't tell them that, hey, I got my wife in the back seat and, she's pregnant, I'm trying to get to the hospital. Look, to your point, the officers may say, hey, I'm going to turn on my blues and I'm going to get you there faster, and they may let you go, but you still broke the law, right? You still violated a statute or a regulation or a laws. But when you start talking about LCDs, right? Because you were just talking about sub-regulatory guidance or quasi-regulations. This is where strict liability issues often come into play from a CMPL standpoint. Yeah. And I think it's important to understand the difference between a civil versus a CMPL.
Yeah. Well, strict liability is thrown around, but there really shouldn't be any true strict liability. And the reason why is because from a Medicare standpoint, medical necessity is really going to drive the determination. I think you can quote chapter and verse the part of the policy manual which discusses that. So, let's say, and I use back injections because that's the case that we dealt with. Let's say there's an LCD or even an NCD saying you can't do more than 5 injections during a calendar year, or you must do a radio frequency ablation after you do an injection,
Right.
the response could always be medical necessity for the patient dictated the reason why I delivered this care, and then you show that to them and you deal with it. So, we do talk about strict liability because I think from the civil monetary penalty side, there may be a few items out there where you could be considered strictly liable. Maybe people might hit me for this analysis, but maybe telemedicine may be a good example.
I think that's a great example.
We have a very clear explanation of what Medicare will cover for telemedicine. We have telemedicine companies out there violating that like it's cool, and then coming to us saying we didn't intend to engage in fraud. If it's a fraud case, I have an intent defense. This doctor didn't know that that was a violation of the regulations. If it's a civil case, really, really difficult when you engage in a telemedicine practice and build Medicare. Maybe genetic testing, maybe another good.
That's another good one because, again, that's a huge audit target.
Right.
These laboratory services, I know, Eric, you and I are working on some cases together about this. But, go ahead. I think you had a thought on
No,
that.
I mean, my only thought was, like, when we're talking about the telemedicine world, is that, when the payers come out with a specific rule that says, the one that we saw most frequently was you were going to get a bundled payment during COVID for testing. And that was particularly in the urgent care world. We saw that a lot in the urgent care world. You come in for a COVID test, you see a nurse practitioner, you're going to get one payment, and that one payment is going to contemplate the evaluation and management and the COVID test. We're not going to pay you separately. And what providers were doing was they were just appending modifier 25 to just say, hey, we want to get paid for this.
Yep.
And their justification later on is, well, we were billing the lowest level. We have to evaluate every patient. How do we know that they have COVID? Maybe they have the flu. Maybe they have bronchitis. Maybe they have this. It's like, but there's a written policy. At the end of the day, everybody walking in the door were patients coming in for COVID. But more importantly is, before COVID, you didn't have a single nurse practitioner working in your urgent care center.
Yeah.
Now, COVID comes, and you hire a bunch of NPs to do these E&Ms and to do the COVID testing. So how do you articulate the fact that you weren't intending to do something when you've actually set yourself in motion to do this?
Yeah.
Like the fact that, I remember asking this to a couple of guys who, they opened up an urgent care center right before COVID, and then COVID hit. And I said to them, what were the days and times and shifts that your NPs worked? And none of the NPs existed before COVID. They said, we hired the NPs to do the COVID testing. I said, well, you can't have it both ways.
Yeah.
That's
You get the
right.
bundle payment.
And again, you brought up the modifier 25, which is always, an interesting conversation to have, because to me, next to the 59 modifier, that's a key fraud modifier, right? Because you're using it to unbundle an evaluation and management service from another service that's supposed to be significant, separately identifiable, above and beyond a pre-service workup.
And by the way, forgetting the fact that the payers are doing their crackdown on 25 and 59 that we're seeing with reducing documents to fax and this and that. At the end of the day, the modifier 25 is a target. When I was an OIG agent, we would get our billing reports, and there would actually be a separate tab on the use of modifier 25 for that provider. It's a known area of fraud. So why providers continue to put themselves in this peril it's still mind-boggling to me.
Yeah, I don't know. But, real quick, Ron, I want to go to a discussion about LCDs for a minute. Because, there's always these arguments that are brought into court about the significance of an LCD and how that plays with a jury, between how a prosecutor explains it versus how defense counsel explains it. And the stark difference between them painting it as, the be all end all versus the fact that this is just a guideline.
Yeah. You mentioned stark difference. I hope that was a pun and an intentional one. Healthcare puns are my favorite. But listen, there's a number of cases. There was one in the Eastern District of Michigan in front of Judge Hood. It was an injection case as well. They tried to make their case entirely based on exceeding local coverage determinations. I wasn't involved in that case, but I had it on appeal, and defense counsel did not battle the LCD. There's a jury instruction that should come into every one of these cases that says civil regulations are not sort of de facto or per se proof of fraudulent conduct. What the defense attorney needs to do, for all the defense counsel listening out there, is get that jury instruction. It's offered in most circuits, and then show the LCD and point to it and say, this instruction was made because of this type of garbage. LCDs coming in and trying to hold a doctor criminally liable because of it. And then further, what you need to do is have somebody like Sean Weiss get on the witness stand and clearly explain to the jury, hey, you all work in your own separate fields. You know how sub-regulatory guidance works. Maybe you're an accountant. You know what sub-regulatory IRS guidance looks like, right? And you know that it's oftentimes very fuzzy. And explain why these things do not have the force and effect of law, and then go one step further. And every time somebody exceeded the LCD, show exactly why it was necessary on a patient-by-patient basis. You walk the jury through those steps, and you'll get closer to the path towards acquittal.
Yeah, this was such a fascinating panel discussion that we had today. There's so much to explore. I think as we continue to see 2023 evolve, as we start to get more rulings, as we start to see more things coming down the pike, again, we're waiting for CMS to make a determination as to whether or not they're going to adopt the criminal language of the False Claims Act for the civil, which I think would be a huge mistake.
Yeah.
But we have an opportunity to really continue to push information out to all of our listeners, our viewers, keeping you all informed. Eric, last thing that I want to talk about real quick, and then we'll wrap this up. During the prior administration, you had Rachel Brand and you had Jeff Sessions, who pushed out the memos, right? The Brand memo, the Session memo, that basically removed the arrows from the quiver of the prosecutors, if you will, to be able to say, you cannot use sub-regulatory guidance documents from another entity to be able to make a charging decision against somebody. Now that's all been revoked under Garland and his memo. So from a law enforcement standpoint, and then Ron, I want to get yours right after this as a defense counsel. From your perspective as a retired law enforcement professional with the Office of Inspector General, how does that help or hinder a case, having access to sub-regulatory guidance?
Yeah, so that actually becomes really important, because when you're going to an AUSA who's never worked on a particular case, so people say I pick on podiatrists a lot, but we'll use podiatry. That there's a very specific set of rules regarding routine foot care, right? Sometimes it's known as the 60-day rule, sometimes it's the 61-day rule, and it talks about what you can and can't do, and it's very clear. And when you go to an AUSA and you say, here's the case, here's the billing data, here's what it shows, I talked to these patients, this is what they say. An AUSA is always going to say, outside of the statute, they're going to say, what does the regulation say? Because, and you guys know this, that you can have instances where it looks like fraud, it smells like fraud, it acts like fraud, and then there's a policy that says you can do this.
That's
right? And then your case goes away. And so the importance of having that sub-regulatory guidance being treated as the law of the land is, as an investigator, to be able to go to an AUSA and say, hey, I just did this whole investigation. This podiatrist was out there billing for routine foot care. They were circumventing the billing codes. This is what the billings show. I talked to the patients. This is what they said. This is what the policy says. Because then ultimately an AUSA is going to go, aha, that's what I'm going to rely upon. So putting that sub-regulatory guidance back into the fold is a game changer from a law enforcement perspective. From a defense perspective, it's a game changer, because now you got to go back to rethink the things that you didn't have to think about beforehand. But I would say that it definitely greased the skids if you were working on a case in which there was an issue that directly fit into an NCD or an LCD.
Yeah, and Ron, I'll go to you with that same question from a litigator's perspective. Obviously the Garland memo, revokes everything that was put in during the Trump administration, right? To make it more difficult, if you will, to use sub-regulatory guidance in bringing a charging decision against, somebody who is accused of committing a crime. What does that do for you as a litigator? Does it make your job harder, or how do you attack it?
Well, it makes it harder because the Garland memo makes no sense. We've got Alina out there. It gives very relatively clear guidance on how this sub-regulatory guidance can be used. And then we've got the Sessions memo that said we're going to comply with that, right? This stuff needs to be promulgated, otherwise it can't be used to create an affirmative duty. And then Sessions was like, yeah, I sort of agree with the Supreme Court, but yeah, we can sort of use it, but we can't use it to create an affirmative duty, but we can sort of use it in the course of our investigation if I'm reading the memo correctly.
Right.
And it doesn't tell, the problem is that by trying to erase what Trump did with the Sessions memo, or Sessions did with the Sessions memo, and replacing it with something that is more watered down, it gives DOJ prosecutors some wiggle room to say, we're looking at this, but no, we're not using it, but we're looking at it. And it doesn't clearly say to federal courts, this memo will not come into evidence against you as affirmative evidence. Here's the way I look at these sorts of, or the LCDs. Here's the way I look at these LCDs. They're de facto expert testimony by an unqualified expert.
There you go.
When in the history of the law could you ever have a document come in the stand that was created by somebody who purports to be an expert but is not?
That's
MACs
right.
are not doctors. They may consult with doctors,
That's
but
right.
they're not. And they're putting evidence in to say what an affirmative duty is. That's a mistake. They should not be admissible. And I think the Garland memo makes that issue much more confusing. I didn't completely answer your question.
No, but you
I
did.
jumped on my soapbox.
No, you did, and what you did was you actually brought to light the contradictions that exist, in a DOJ that is hell bent, in my opinion, on exacting a pound of flesh in every single case, right, wrong, or indifferent, against those who really, it never should have escalated to a criminal matter. If anything, it could have been handled civilly or administratively. And that's where I get really upset about some of this stuff.
And maybe not hell-bent on exacting a pound of flesh, but hell-bent on making everything so gray
Yes.
that they get to decide what is a violation and what is not. And that's the way we're moving. Healthcare providers don't have clear standards. The policies are changing, and that gray is used against people constantly, and that's the concern.
Absolutely. All right. Well, that's going to wrap it up for us here at the HCCA conference in Anaheim, California. Once again, I had the absolute honor and privilege of hanging out with two of my very good friends, Ron Chapman of the Chapman Law Group and Chapman Consulting Group, and Eric Rubenstein of Advise Healthcare Consulting. We'll be back most likely later today or tomorrow with another short segment here from the HCCA conference. To each and every single one of you, thank you so much for tuning in, logging on, and hanging out with us each and every single day. We appreciate you. We're going to be back not too long from now. So until then, remember, be good to yourself, but more importantly, y'all be good to each other. Take care.